In this podcast, I'm going to give you a rundown of the new Domestic Abuse Act, which has recently received royal assent, so it's become legislation. I'm going to give you a rundown of some of the new things that have been introduced as a consequence of this, and also to comment. All bearing in mind that if you need to prove domestic abuse, you need to understand what you have to prove. And the purpose of this podcast is to help you to understand the kinds of things that amount to domestic abuse and the kinds of things that you need to bear in mind if you're going through something like this and you're wanting to gather evidence so that you can either go to the police or you can go to a lawyer for help because you want to get this terrible issue sorted out. So first of all, I'm going to the government website. We're going to give links at the bottom of the video about what I'm reading from, so you can dig deeper. I'm going to be taking sections from this. I'm not going to be reading everything completely. So here we have the first thing from the Gov website, which I'll read and I'll comment on, as I said. Today, the 29th of April, that's this year, the Domestic Abuse Bill has passed both Houses of Parliament and been signed into law. That means it's been made an act. The Domestic Abuse Act will provide further protections to the millions of people who experience domestic abuse and strengthen measures to tackle perpetrators. All of this is very important. We're seeing that it's going to give further protection. So it should give you a better chance of being protected, and also it's going to introduce measures to take a grip of the perpetrators, hopefully, and get them to behave differently with a bit of luck. For the first time in history, there will be a wide-ranging legal definition of domestic abuse, which incorporates a range of abuses beyond physical violence, including emotional, coercive or controlling behaviour, and economic abuse. Going back a number of years, it used to simply be violence, but of course we all know that it's much more than violence that leads to terrible relationships between people, and all these other kinds of behaviours can do tremendous harm, and so it's a good job that this is now being recognised. The measures include important new protections and support for victims, ensuring that abusers will no longer be allowed to directly cross-examine their victims in the family and civil courts. That was a horrendous thing that used to happen, and it's a good job it's not allowed anymore. And giving victims better access to special measures in the courtroom to help prevent intimidation. Those kinds of measures are protective screens, where in fact you sit behind a screen to give evidence, or even better probably is giving evidence via video link. So you're not in the courtroom, you are giving it in a part of the court building somewhere else, and you're just seen on a video link in the court itself. Police will also be given new powers, including domestic abuse protection notices, providing victims with immediate protection from abusers, while courts can hand out new domestic abuse protection orders to help prevent offending by forcing perpetrators to take steps to change their behaviour, including seeking mental health support or drug and alcohol rehabilitation. So that's a huge move forward, and one which hopefully will be taken up and used by a lot of perpetrators. In recent weeks, the government has added new measures to the bill to further strengthen the law, including creating a new offence of non-fatal strangulation, extending an offence to cover the threat to disclose intimate images, so it's no longer doing it, but it's threatening to do it, and clarifying the law to further clamp down on claims of rough sex gone wrong in cases involving death or serious injury. The Domestic Abuse Bill was originally published in draft for pre-legislative scrutiny, and the government worked closely with the Domestic Abuse Commissioner and charities to make key changes to the bill, ensuring the law is as robust as possible. Other measures included in the Act: these are extending the controlling or coercive behaviour offence to cover post-separation abuse. So that's really interesting and helpful. So if you've separated and you're still finding that you're subject to economic abuse or any form of abuse at all, you can continue to keep evidence of that and know that it will be taken into consideration. And the fact that you're living separately is no longer allowing somebody to abuse you without fear of anything happening. Explicitly recognising children as victims if they see, hear or experience the effects of abuse. I think this is one of the most important parts of the legislation, having been a children panel solicitor for years. It's really important, obviously, to protect children, and what they see, hear or experience does cause harm and long-term harm. And so it's really important that that is caught in this Act as something that people need to take account of. Establishing in law the Office of Domestic Abuse Commissioner, placing a duty on local authorities in England to provide support to victims of domestic abuse and their children in refuges and other safe accommodation, provide that all eligible homeless victims of domestic abuse automatically have priority need for homelessness assistance. Both of those should be recognised by local authorities to include men and women, so that they need to be responsible for that. And let's keep an eye on that and see if this happens, and that, for example, there are more refuges for men. Because what we've been learning as we've been doing our interviews and podcasts is there are very few places for men and far more for women. And finally, placing the guidance supporting the domestic violence disclosure scheme, what we commonly call Clare's Law, on a statutory footing. So just to remind you, with Clare's Law, you can make a domestic violence disclosure scheme application. What that means in normal language is it allows a member of the public to make an inquiry into the partner of a close friend or family member. So the scheme allows any member of the public the right to ask the police if their partner may pose a risk to them. And it's called Clare's Law because of a landmark case. It's named after that. So that's become recognised now as on a statutory footing. Moving on. This is another part of Gov.UK's website. This is the actual legislation. What I'm going to do is go through just 2 or 3 of the preliminary sections, giving a little bit more padding to the information. Remember, I'm doing this because if you have this problem, you need to be able to prove it. You need to be able to prove it so the police can take action, or prove it so that you can go to the civil courts and you can get the orders that you need. And it's really important, therefore, to understand that if you're going to be providing evidence, and one way or another you're going to have to provide the evidence, otherwise nobody can help you, you need to understand what it is that you have to have. And so the reason I'm doing this and taking it quite slowly and carefully is the importance of gathering evidence if you're to get redress for the things that are happening to you. So the legislation, we can start with Section 1, definition of domestic abuse. Here we go. So, domestic abuse is defined for the purposes of this Act as behaviour of a person A towards another person B is domestic abuse if A and B are each aged 16 or over and are personally connected to each other, and B, the behaviour is abusive. So you have to be over 16, you have to be connected to one another, and the behaviour has to be abusive. Then they go on to define abusive. Behaviour is abusive if it consists of any of the following. So I'll go through this very slowly. A, physical or sexual abuse. B, violent or threatening behaviour. C, controlling or coercive behaviour. D, economic abuse, E, psychological, emotional or other abuse. So those are the things you need to be able to show is happening to you if you are to prove it and get your application dealt with properly. It carries on. It does not matter whether the behaviour consists of a single incident or a course of conduct. So a single incident counts. You don't have to prove a course of conduct. There will be occasions, though, where you've been living through hell, really, and lots of different things have been happening. And so record the lot. Give examples. Do it very carefully in the way that we recommend with the mobile app. There are other podcasts coming about that, and that will help you. Then comes economic abuse. That's defined in subsection 4. Economic abuse means any behaviour that has a substantial adverse effect on B's ability to A, acquire, use or maintain money or other property, or B, obtain goods or services. So that's the definition. 5. For the purposes of this Act, A's behaviour may be behaviour towards B, despite the fact that it consists of conduct directed at another person, for example, B's child. Now we move on to section 2. That gives you the definition of personally connected. That goes from A to G. I won't go into that because really you can do this yourself. You can go and check this out and then you can see whether you are personally connected. So one example would be you're married to the person. Another would be you're civil partners with one another. And it goes on then to define people who have a person who has parental responsibility. And then section 3, children as victims of domestic abuse. And as I said earlier, one of the most important factors. This section applies where the behaviour of person A towards another person B is domestic abuse. Any reference in this Act to a victim of domestic abuse includes a reference to a child who A, sees or hears or experiences the effects of the abuse, and B is related to A or B. There's more, but I'll leave that for you to read, to dig deeper into this so that you can understand it more. What I hope I'm showing to you is that if you actually go online, you can find out a tremendous amount of stuff about what you need to know. And you need to know it because if you have these problems or if you are connected to someone who has a problem and you're helping them, this is a really easy way to make sure that you or they are gathering all the evidence that they should. And they're gathering the right things. They are collecting evidence of the right things that actually will mean that they get help. Now, the Act also gives a lot of information and reference to the domestic abuse protection notices. Those are the things that the police can hand out, if you remember, when I spoke at the beginning of this podcast. And then the domestic abuse protection orders. This is a complete podcast in its own right, so that'll probably be one of the next podcasts that I do. So you understand about notices and you understand about orders, the kinds of orders that can be made, the courts that are able to make these orders, and that's going to be, as I say, another useful podcast. And then I just wanted to find for you, so part 6 lists controlling or coercive behaviour, which I won't go into, but disclosure of private sexual photographs and films. So this is in section 69. And it says, Section 33 of the Criminal Justice and Courts Act 2015, disclosing private sexual photographs and films with intent to cause distress, is amended, and the amendment is we now have it threatening to disclose as well as actually doing it. And that's a real breakthrough, I think, because threats are just as worrying as actually disclosing. So that's a very important improvement. Then offences against the person, strangulation or suffocation. So a person commits an offence if A, intentionally strangles another person, B, or A, does any other act to B that affects B's ability to breathe and constitutes battery of B. It goes on. It is a defence to an offence under this section for A to show that B consented to the strangulation or other act. But subsection 2 does not apply if B suffers serious harm as a result of the strangulation or the other act, and A either intended to cause B serious harm or was reckless as to whether B would suffer serious harm. So this is firming up the legislation, and it's an important move forward. And anybody who's listening to this, if this has happened to them, remember, go back to what I said earlier, a single incident is enough for you to have evidence. So you can go to the police, you can take action about that. And it's a kind of beware, really, advice I have there. Be careful what's going on, because without agreement and in certain circumstances you could find yourself really in hot water. Finally, take a look at our website and you'll see the guidance that we have there. We've got how-to guides, we've got a lot of detail about individual things such as domestic abuse. We've got blogs that might be interesting and helpful. We've got case summaries. All of that's on the website, as I say, and we'll put a link at the end of the bottom of this video. And finally, we've got podcasts. I've done podcasts a while back on coercive control, and if you go back to that, it's got a long list of examples of coercive control, which I've taken from the Crown Prosecution Service website. I've looked at that website this morning and it's still the same. So if you go to the CPS website, you'll find that there. But that gives you loads of examples of the kinds of things that you could be recording that would count as evidence. And it's really important that you know what you're doing. So make sure you understand what it is you're trying to prove. And then if you use the app will help you do it take a certain procedure. You will follow the same course each time you keep a record, and that will help you when you seek help, because you've got a chronology, a timeline. In other words, a list in date and time order of the things that have happened to you that either singly or together will provide enough evidence for you to be able to get a satisfactory outcome.